Welcome to CM Guide podcast series. All right, let's unpack this. Imagine you're a builder, maybe a subcontractor, or really anyone who's deeply involved in the building and construction industry here in Queensland, Australia. You've poured your time, your effort, your resources into a project, you've done the work, but then payment isn't coming through. It's a frustrating scenario, isn't it? Often devastating. But crucially, it's one that a very specific set of laws aims to prevent and resolve. What legal tools do you actually have at your disposal to make sure you get paid for the work you've done? That's precisely what we're diving into today. The intricate, yet absolutely vital world of Queensland's security of payment legislation. It's definitely an area that's both complex and foundational for keeping cash flowing and ensuring fairness across the entire contractual chain.
It absolutely is. And what's fascinating here, I think, is how Queensland's legislation in this space has genuinely evolved over time. It hasn't just stayed static. It's been continually shaped and refined, to directly address the common challenges the industry faces. The overarching goal really has always been about keeping money flowing down to those who are actually doing the work on the ground.
So it's a dynamic system, not just set in stone.
Exactly, which makes understanding its history and, importantly, its recent changes so critical for anyone operating within this space today. The core insight, I'd say, for anyone in the industry is that this act is continuously evolving. They're tightening loopholes, empowering claimants. This means staying updated isn't just, good practice, it's essential. Essential for both securing your payments if you're a contractor and for diligently managing your obligations if you're, say, a head contractor.
Okay, Section 1, laying the foundation. What is security of payment legislation? That's a perfect point to start. Before we get into the real nitty-gritty of how it works today, let's lay that foundation. What was the landscape like before these modern laws came into being? And what core problem were they really trying to solve for people like you out there in the industry?
Well, look, prior to the current regime, the main way subcontractors in particular could try and secure payments was through something called the Subcontractors Charge Act 1974. Now, while it did offer some protection, it was often criticized. People found it quite slow, cumbersome, really, and maybe not as broadly applicable as the industry needed.
So not ideal then.
Not really, no. It was a more difficult process to navigate. So to address those limitations and provide a quicker, more effective alternative, the Queensland Building and Construction Industry Payments Act 2004 came along. We often just call it the Queensland Act. It came into force on October 1st, 2004. This new act had a much wider application, and it was actually very closely modeled on the New South Wales Building and Construction Industry Security of Payment Act 1999.
Right, so drawing on what was happening interstate, the idea was to streamline things, cast a wider net for payment protection.
Precisely.
Were there any immediate significant differences between Queensland's new approach and that New South Wales model it was based on right from the get-go?
Yes, there were definitely some key distinctions that set Queensland apart from the beginning. For instance, Queensland put in place a different, more specific adjudication process for payment claims over a certain threshold, $750,000.
Oh, okay, so different track for bigger claims.
Exactly. That was a notable divergence from New South Wales. And also, and this is quite unique to Queensland, they introduced the role of an adjudication registrar. This registrar isn't just some administrative body. They have really significant responsibilities. They centralize and oversee the entire adjudication system. They handle the registration of adjudicators, making sure they do the necessary exams and ongoing professional development.
So a gatekeeper, in a way.
You could say that. And they're also responsible for receiving all adjudication applications, impartially selecting who handles which claim, setting up fee agreements with those adjudicators, and, importantly, publishing all the adjudication decisions. This centralized control over who gets appointed and the transparency of decisions was a hallmark difference right from the start. It was designed to ensure fairness and, avoid any perception of bias.
That sounds like a pretty significant step forward, trying to head off those concerns about impartiality right from the start. But as you mentioned earlier, these laws are constantly evolving. What were some of the major reforms we've seen since that initial 2004 Act? How has the law adapted to feedback from the industry itself?
Well, after about a decade of the Queensland Act being in operation, it underwent substantial amendments. This was back in December 2014 through the Building and Construction Industry Payments Amendment Act. These reforms were really a direct response to industry concerns. There was a feeling the original act wasn't quite hitting the mark as effectively as hoped.
So industry feedback was key.
Absolutely. The goal was to sort of reinstate confidence in the security of payment laws, maybe reduce the regulatory burden and the costs associated with adjudication, and just foster a fairer, a more transparent process for everyone involved. It was really about refining the system based on how it was working in the real world, identifying where the bottlenecks or perhaps the unfairnesses were.
Okay, so a tune-up in 2014. And then in 2017, we saw another really big shift, didn't we? This was the introduction of the Building Industry Fairness Security of Payment Act, or the BIF Act, as everyone calls it. I know this is a huge one for anyone listening who's in the industry.
Yes, that was indeed a major turning point. The Building Industry Fairness Security of Payment Act 2017, the BIF Act, actually commenced on December 17th, 2018. It brought with it, well, numerous benefits for claimants, but it also presented increased challenges for respondents. The aim was clearly to strengthen the position of those seeking payment.
How so? What changed specifically for claimants?
For claimants, the BIF Act did a few key things. It eliminated the previous requirement to specifically endorse a claim or invoice with certain words. That often caused technical problems, valid claims getting knocked back on a technicality. It also extended the timeframes for submitting a claim, giving parties a bit more flexibility. And crucially, it established a statutory reference date even after a contract had been terminated.
So you could still make that final claim under the Act.
Exactly. It ensures there's always a mechanism for final claims under the Act.
Okay, and on the flip side, you said it increased challenges for respondents. What did that look like?
Well, respondents faced a significantly higher bar. There was a heightened risk of what's called default judgment if they failed to provide a payment schedule on time. Essentially, that could mean they had to pay the full claimed amount, even if they disputed parts of it, just because they missed the schedule deadline.
Wow, serious consequences.
Very serious. They could even face potential disciplinary action under the Queensland Building and Construction Commission Act 1991, the QBCC Act, for not providing that schedule, or for failing to pay amounts decided by an adjudicator. The BIF Act also removed any sort of second chance to respond to a payment claim. It really emphasized the importance of getting your payment schedule right the first time. It mandated that respondents had to specify all their reasons for withholding payment in that initial payment schedule, regardless of the claim's value. This closed loopholes where new arguments could be brought up later in adjudication.
So, a full disclosure up front.
That's the idea. The BIF Act also updated and streamlined the old subcontractors' charges provisions, bringing them in from the separate 1974 Act. While the core function remained similar, it introduced a new requirement for higher contractors, say a head contractor, to respond to a subcontractor's notice of claim within 10 business days. And they also had to notify parties further up the contractual chain. Beyond these specific payment mechanisms, the BIF Act also introduced a bonding scheme, though that's perhaps a larger topic for another day. But the upshot of all this: a significant shift towards empowering claimants and demanding much more rigorous compliance from respondents.
It certainly sounds like the BIF Act really tilted the scales further towards ensuring claimants get paid. It heightened up the process significantly, making it much harder to, well, drag things out or avoid payment. But what about even more recent changes? I understand there have been further tweaks, particularly affecting things like trust accounts.
That's right. More recently, in 2020, we saw the Building Industry Fairness, Security of Payment, and Other Legislation Amendment Act 2020 come into play. This act specifically amended the BIF Act again, adopting key recommendations from various industry reports. A really significant change was the replacement of the existing project bank account framework, which applied to certain Queensland government construction projects. This was swapped out for a simpler statutory trusts regime. It's designed to manage subcontractor payments and retention monies more efficiently.
What does that mean practically for, say, a subcontractor?
Well, it means money intended for subcontractors on eligible projects is held in a trust, separate from the head contractor's general funds. This makes it much safer if, for example, the head contractor runs into financial trouble. These amendments also significantly enhance the QBCC's authority to enforce these project trust requirements. They introduce new penalties for noncompliance. The QBCC, as the statutory body, now has a stronger hand in making sure these trust rules are followed.
More teeth for enforcement, then.
Definitely. Furthermore, these 2020 amendments establish new rights for contractors and introduce penalties for principals, the project owners who fail to pay certified or adjudicated sums by their due date. And this applies to all construction contracts across Queensland now, not just government ones. And there were even more practical additions introduced. The amendments brought in something called Payment Withholding Requests.
Payment Withholding Requests, what are they?
They're a security of payment mechanism, actually quite similar in concept to the older Subcontractors Charges Act, 1974. They're specifically available to contractors who have successfully obtained a favorable adjudication determination. This new regime aims to shield claimants who win an adjudication from the risk of non-payment, especially from respondents who might be teetering on the edge of insolvency.
How does it shield them?
Well, notably, it allows a head contractor, for example, to issue a payment withholding request directly to the principal's financier, their bank. So if a principal owes you money after an adjudication says so, you might be able to go directly to their bank to stop funds being released elsewhere.
That sounds powerful.
It is. Though it's important to point out, this doesn't extend to resident owners doing domestic work. Alongside this, the amendments introduce the concept of a charge over property where the construction work was performed. This is also contingent on getting a favorable adjudication determination.
A charge over the property, like a lien.
Exactly. It offers another avenue for securing payment by effectively putting a legal claim or lien on the property itself until you get paid.
So really strengthening the enforcement options for those who get a favorable adjudication. It's like once an adjudicator says you're owed the money, the law gives you more immediate and powerful ways to actually go and get it.
That's a very good way of putting it. It adds real teeth to the adjudication outcome.
And I believe there's an even more recent update. Literally just came into effect this year from July 4, 2024.
Correct. The Building Industry Fairness, Security of Payment, and Other Legislation Amendment Act 2024. It was introduced in February and became effective from July 1st, 2024. These very latest amendments primarily aim to further simplify that trust account framework we just talked about.
Simplify it how?
Well, the goal here is to reduce compliance complexity and costs without actually adding new requirements while still preserving those essential protections for subcontractors. Specifically, these simplifications include refining the definition of who qualifies as a subcontractor beneficiary for trust accounts and also streamlining the trust record-keeping requirements. The government is also collaborating with software providers to make sure there are compliant products available to make this easier for businesses to manage.
Any other key changes in this latest round?
Yes, interestingly, due to some initial record-keeping and software limitations identified, the requirement for independent account reviews for these trusts has been paused for now. They also removed mandatory retention trust training requirements. And they clarified that trust account balances are excluded from minimum financial requirements reporting the MFR reporting.
That MFR point sounds like a significant relief for businesses.
It is. It helps with their financial capacity calculations. Lastly, the Act clarified some transitional provisions for the new phases of the trust framework, just to ensure a smoother rollout as these changes are implemented across different types of projects.
So it's truly, like you said, a complex machine that's been constantly fine-tuned. Each amendment seems to plug a gap or smooth out a rough edge based on real-world feedback. It sounds like a continuous process of trying to get it just right.
That's an excellent analogy. It really is a living piece of legislation. It has to adapt to the nuances and challenges of a vital industry that is itself constantly evolving.
Which clearly shows, I suppose, the government's ongoing commitment to trying to make sure people get paid in this industry.
I think that's fair to say. The intent is certainly there.
Given all these layers and evolutions over the years, it leads me to wonder, where exactly do these laws apply? And importantly for you listening, are there any specific types of work or contracts that are excluded from the BIF Act's reach? Because this is absolutely critical, isn't it? If your contract doesn't clearly fit the definition, you might find yourself without the very protections the BIF Act offers.
That's a critical question for anyone in the industry, absolutely. It defines your eligibility to even use these protections. So the BIF Act specifically applies to construction work undertaken in Queensland. However, it does have some explicit exemptions. For instance, domestic building work, that is, work on homes for resident owners, is generally exempt.
Okay, so home renovations for the owner-occupier are usually out. What about defining construction work?
When it comes to defining what constitutes construction work and related goods and services, the Act adopts definitions that are pretty similar to those found in the New South Wales Act. But importantly, under the BIF Act in Queensland, construction work also includes building work, as it's defined under the Queensland Building and Construction Commission Act 1991. This broadens its scope somewhat, potentially capturing more types of building activities than in some other states.
Are there specific industry exclusions, like mining or resources?
Yes, there are. The Act does not apply to drilling for or the extraction of oil or natural gas. It also excludes the actual extraction of minerals, whether that's done by underground or surface working, and this includes any tunneling, boring, or constructing underground work specifically for that purpose of mineral extraction.
So the core mining activity itself is excluded.
Right. But it's worth noting that this mining exclusion has been judicially clarified. The courts have said it applies solely to the actual extraction of minerals, not necessarily to all activities that happen within the mining industry on a mine site.
Ah, that's an important distinction.
It is. So preparatory work that's necessary for mineral extraction later on, for example, might still fall under the BIF Act scope. That's a very important nuance for contractors working on mining sites to understand.
That distinction between actual extraction and preparatory work sounds like a very important detail indeed, one that could significantly impact whether you're protected or not. But I understand there's a practical issue that frequently arises, even with these definitions, causing claims to fail before they even get properly considered.
Yes, unfortunately, despite the clarity the Act tries to provide, a significant number of adjudication applications are actually dismissed by adjudicators because there's a fundamental lack of jurisdiction.
Lack of jurisdiction, meaning?
Meaning, the adjudicator decides the claim doesn't legally fall under the BIF Act. This often stems from the non-existence of a construction contract as defined by the BIF Act or similar grounds. Essentially, the contract itself doesn't qualify for the Act's protections, and many other adjudication decisions have been successfully challenged in court by respondents for this very reason.
So what does that suggest?
Well, this outcome suggests a clear need. Either we need to better define the jurisdiction of adjudicators within the Act itself, or perhaps more practically, we need to better educate both adjudicators and construction stakeholders, people like you listening, on what actually constitutes a valid construction contract under the Act. Improved awareness of how the BIF Act applies would hopefully help avoid these invalidations and ensure the system functions as intended, saving everyone time and, frankly, money.
Okay, Section 2, the heart of the process, payment claims and adjudication. So we've covered the why and the evolution. Now let's bring it down to brass tacks. For you, the person on the ground, maybe a subby or a head contractor, what are the actual fundamental steps you need to take within this system? It all begins with progress payments and something called reference dates, doesn't it?
It does, yes. The BIF Act grants you an entitlement to progress payments. This is a crucial aspect because this entitlement exists regardless of whether your specific contract actually makes provisions for progress payments or not.
So it's statutory right.
It's a statutory right outlined in Section 8 of the Act. It's your right to be paid for work done on a periodic basis. Key to this is understanding the reference date. This is either a date specified in your contract for making a progress payment claim, or if your contract doesn't specify one, then it's the last day of the month when the construction work first commenced or goods services were first supplied, and then it's the last day of each subsequent month after that.
And what if the contract gets terminated?
Good question. If your contract is terminated and it doesn't specify a reference date beyond termination, the final reference date is simply the date of termination itself. From each of these reference dates, you become entitled to a progress payment if you've carried out construction work or supplied related goods and services under the contract during that period.
And what about the timing of these payments once you've actually made a claim? Are there strict deadlines for when you must be paid?
Yes, there are very strict due dates for payments, and these are absolutely vital for maintaining cash flow in the industry. A progress payment becomes payable either on the day specified in your contract.
Okay, if the contract says something.
Right. Or if the contract doesn't specify a date, it becomes due 10 business days after a payment claim for that progress payment is made. Importantly, the Act explicitly makes it absolutely clear that pay-when-paid provisions are ineffective. They simply don't stand up under the Act.
Can you explain that? What's a pay-when-paid provision?
It's where, say, a head contractor tries to put a clause in their subcontract saying they'll only pay their subcontractor when they themselves get paid by the principal or the client. The BIF Act says, nope, you can't do that.
So a head contractor cannot legally withhold payment to a subcontractor just because they haven't been paid by the principal.
That's exactly right. It's a huge protection for subcontractors down the chain. There are also specific, even tighter time limits that apply under the QBCC Act. No more than 25 business days for construction management, trade contracts, or subcontracts, and no more than 15 business days for commercial building contracts, so even shorter timeframes in some cases.
That's a significant detail, especially for cash flow, knowing you can't be held hostage by someone else's payment delays up the chain. You also mentioned business days earlier. Is there anything unique about how business day is defined in Queensland? especially around holidays, which could potentially trip someone up if they're not careful.
Indeed, there's a very practical and unique aspect to Queensland's definition of business day. While the BIF Act generally uses the term similarly to other places like New South Wales, it specifically excludes the period from December 22nd right through to January 10th from the definition of business days.
The Christmas break, basically.
Exactly. This is set out in Schedule 2 of the Act. The reasoning behind this exclusion is pretty straightforward. It reflects the common industry shutdown period over the Christmas and New Year holidays. It also serves to counter a situation that used to happen, where payment claims and even adjudication applications were strategically served during these popular holiday periods.
Ah, when offices might be empty or running on skeleton staff.
Precisely. Creating what were sometimes referred to as ambush attacks that could cause maximum disadvantage to respondents trying to deal with them over the break. This exclusion helps prevent that, allowing everyone a proper break without fear of being caught out by a ticking clock.
Okay, that specific definition of a business day ties directly into the strict process we're talking about. Here's where it gets really interesting. The whole process really kicks off with the payment claim itself, which then triggers the requirement for the other side to provide a payment schedule. Can you walk us through those crucial first steps? First, from the perspective of someone like a subcontractor making a claim, and then how a head contractor needs to respond.
Certainly. So as a claimant, let's say you're the subcontractor and you're entitled to a progress payment. You can submit a payment claim to the respondent, the person liable for payment under your construction contract, usually the head contractor in this scenario. The timing is important. Unless it's a final payment claim, it must be submitted within the longer of either the period specified in your contract or 6 months after the last construction work was carried out or goods services were provided.
6 months is the default backstop then.
Yes. For final payment claims, the timeframes are actually longer and depend on things like the end of the defects liability period or 6 months after all work or goods services are completed under the contract. A key rule to remember is that you're only allowed one payment claim per reference date. But, importantly, that claim can include amounts that you might have claimed previously but haven't been paid for yet.
Right, so you can roll over unpaid amounts.
Correct. And if there's a subcontract involved and it's not part of another subcontract further down, the claimant must also include something called a supporting statement with their payment claim. However, it's worth noting, failure to include this statement doesn't actually invalidate the payment claim itself.
Okay, a bit of leeway there if you forget that bit of paperwork.
Yes, though it's best practice to include it.
So once that payment claim is issued by the subby, what's the respondent's obligation? Let's say you're the head contractor who receives that claim. And what happens if you don't meet that obligation?
The respondent, the head contractor in our example, has a very clear duty under the Act. They must respond to that payment claim by giving the claimant, the subby, a document called a payment schedule. This must be done within the period specified in the construction contract. Or, if the contract doesn't specify a period, then within 15 business days of receiving the claim, whichever time frame is sooner.
15 business days, bearing in mind that Christmas exclusion.
Yes, exactly. And the consequences of failing to provide that payment schedule on time are severe. The respondent may face penalties, possibly disciplinary action from the QBCC, and crucially, they are then required by the Act to pay the full amount claimed by the due date. The Act effectively states that if a respondent fails to provide a payment schedule as required, they must pay the amount claimed to the claimant by the due date. Full stop.
Wow. So no schedule means you likely have to pay the whole lot.
That's the strong incentive. However, it's worth noting, if the respondent simply pays the full amount claimed by the due date anyway, then a payment schedule isn't actually required. They've met their obligation by paying. It's essentially a pay up or schedule up system.
Pay or schedule. Okay. And I imagine these timelines that 15 business days or the contract time are absolutely critical in practice. Can you give us some real-world examples from court cases that highlight just how vital it is to get these right and maybe the pitfalls of getting them wrong?
Oh, these timelines are paramount. And yes, court cases frequently underscore their importance. A really powerful real-world lesson on this comes from the Demex Plea Ltd v. John Holland Plea Ltd case. Imagine you send a payment claim by email on a Saturday thinking you've met a deadline. But the court here basically said, not so fast. What truly matters is proving when that claim was actually received by the other party.
Not just when you sent it.
Correct. In the Demex case, the court found the email was actually received on the following Monday, which, in that specific case, made the respondent's payment schedule timely. This case really highlights that simply sending a claim isn't enough. You must be able to prove its receipt for that clock to officially start ticking. If you can't prove receipt, your whole claim timing might be thrown off, or worse.
Proof of receipt. Okay. That's a key takeaway for anyone sending claims. What else?
Another crucial case is Alencon Ltd Palm Grove Holdings Pony Ltd. Here, the Queensland Court of Appeal highlighted something really important. If your contract specifies a shorter time frame for issuing a payment schedule than the statutory 15 business days, then that contract-specific shorter time frame must be strictly adhered to.
So the contract can override the act if it's tighter.
If it imposes a shorter deadline, yes. In Alencon's situation, their payment schedule wasn't served within the 21 calendar days specified in their subcontract, even though it was served within the Act's default 15 business days. The court ruled the payment schedule was late because it didn't meet the contract's stricter deadline, thereby invalidating it. This really underscores the need for you to be aware of both your contractual deadlines and the statutory ones, and to comply with whichever is the stricter or shorter of the two. Always read your contract carefully.
Read the fine print on deadlines.
Got it.
Any other examples?
Yes, one more. RHG Construction Fidet and Maintenance Pted Ltd v Kangaroo Point Developments. This one clarified an interesting point regarding payment certificates issued by a superintendent, who often acts as an independent certifier on projects. The Queensland Court of Appeal determined that if a contract specifically designates a superintendent's payment certificate as being the principal's payment schedule under the BIF Act, then that certificate is deemed to be the payment schedule for the purposes of the Act.
Even if the principal issues their own separate schedule later.
Exactly. Even if the principal then issues their own document, calling itself a payment schedule within the allowed time. The court said the contract's designation of the superintendent's certificate is binding and takes precedence. So if your contract says the superintendent's cert is the payment schedule, then that's the document that counts, and its timing is critical.
So whether it's proving receipt, sticking to contract-specific deadlines, or understanding exactly which document counts as the payment schedule, these initial steps are clearly fraught with potential pitfalls if you don't handle them precisely. So what happens if that payment isn't forthcoming, even after a proper payment claim has been made? Maybe a schedule has been received, but it proposes less than you claimed, or nothing at all. What are your options then, as the claimant?
Right. If the respondent fails to pay the amount owed by the due date, and that amount owed could be the full claimed amount if no schedule was given, or the scheduled amount if one was the claimant, essentially has two primary statutory options laid out in Section 78. They can either pursue recovery of the unpaid amount as a debt through a court, which is the more traditional, often slower, legal route.
The old way, perhaps.
Kind of, yes. Or, option two, they can apply for adjudication under the BIF Act. This is the faster, more informal process designed specifically for these situations, the one we're focusing on today. Additionally, and this is a significant point of leverage, the claimant can also give written notice of their intention to suspend work or stop supplying related goods and services under the construction contract.
Suspend work. That sounds serious.
It is, but the notice must explicitly state that it's being made under the BIF Act. This ability to suspend work is a powerful tool to compel payment, as it can potentially halt progress on the entire project until the payment issue is resolved.
That definitely sounds like a much more direct path to resolution than potentially getting bogged down in traditional litigation, which everyone knows can be very slow and very expensive. But I understand Queensland has a particularly unique approach to the adjudication process itself compared to other states like New South Wales. Can you explain this dual adjudication scheme? It sounds quite distinctive.
Indeed, it is quite distinctive. The BIF Act is actually the only Australian security of payment legislation to introduce what's called a dual adjudication scheme. This means it provides different procedures for handling what it terms complex payment claims, while still retaining its original scheme, albeit with some alterations, for standard payment claims.
Okay, so two tracks. What defines a complex claim versus a standard one?
For the purpose of this dual scheme, the Act classifies all payment claims that are greater than $750,000, including GST, as complex payment claims. And that's based on the initial claimed amount, even if the actual amount that ends up being in dispute or an issue during the adjudication is less than $750,000.
Ah, so it's the starting claim value, not the disputed amount. Where did that $750,000 threshold come from?
It was adopted because it ties in with the monetary limit of the civil jurisdiction of the District Court of Queensland. However, as you noted, it does create a practical difference. In court, it's usually the amount in issue that determines jurisdiction, whereas under the BIF Act's dual scheme, it's the amount of the original claim that triggers the complex track, even if a chunk of that claim has already been paid or isn't actually disputed.
Why did they introduce this dual scheme? What was the thinking behind it?
Well, the dual scheme was introduced following criticism, really, that the old one-size-fits-all approach under the previous legislation was simply not appropriate or sufficiently robust for dealing with very large or highly complex payment claims involving significant sums and potentially complicated contractual issues. There was a feeling, as Justice Wilson noted in the John Holland Pleaty Limited v. Waltz Marine Services Pleaty Limited case, that while adjudication can be very effective, the standard, very rapid process may be more suited to comparatively small, uncomplicated claims than to large, complex claims, unquote. So the dual scheme attempts to address this by providing a slightly longer, potentially more thorough process for those bigger, more intricate disputes, giving parties and the adjudicator a bit more breathing room.
Aha, moment right there. That's a key differentiator. It recognizes that not all claims are created equal. It provides a more tailored approach for larger, more intricate disputes, rather than trying to force everything, big or small, into the exact same speedy, informal box. Makes sense. So for either type of claim, standard or complex, how does a claimant actually initiate this adjudication process? What are the steps for making the application and getting it referred to an adjudicator?
Okay, so to initiate adjudication, you as the claimant can apply if the respondent either fails to pay the owed amount by the due date, or if the amount proposed in the payment schedule they gave you is less than the amount you originally claimed. The application itself must be submitted in an approved form, which you can get from the QBCC or the adjudication registry, and critically, it must be lodged within specific timeframes.
What are those timeframes?
For non-payment, where no schedule was received or a schedule proposed 0, it's 30 business days after the later of the due date for payment or the last day the respondent had to give a payment schedule. If you received a schedule proposing less than you claimed, you have 30 business days after you receive that schedule. And if you receive a schedule but the respondent paid less than the scheduled amount, you have 20 business days after the due date for that scheduled amount to apply.
Okay, different deadlines depending on the scenario. What needs to be in the application?
The application needs to clearly identify the relevant payment claim and the payment schedule, if one was provided. You have to include the prescribed fee, and you can, and usually should, accompany it with written submissions, detailing your case and why you believe you're entitled to the amount claimed. Crucially, the claimant must then provide copies of this application and any submissions they've made to the respondent, the other party, within 4 business days of lodging it with the registry.
Serve the other side promptly.
Exactly. Once the registrar at the adjudication registry receives the application, they have a duty to refer it to an eligible adjudicator within 4 business days. And just a quick note on serving the documents, a recent case, Iris Broadbeach Business Pleaty Ltd v Descon Group, Australia, Pleaty Ltd in Anor, clarified an important practical point. An automatically generated confirmation form you might get from the QBCC after lodging online is not considered a copy of an adjudication application for the purpose of service under the Act.
So you can't just rely on that auto-reply email. You need to actively send the proper documents yourself.
Precisely. You need to ensure the respondent receives the actual application and your submissions.
Good practical tip there. So once the application is properly lodged and referred to an adjudicator, what's their initial response? Do they have to take the case on or can they decline? And what safeguards are in place to ensure the adjudicator is impartial?
No, they don't have to automatically accept it. Once the registrar refers an adjudication application, the adjudicator has 4 business days to either accept or reject that referral, unless they have a reasonable excuse for not responding in time. Acceptance is communicated through a written notice sent to the claimant, the respondent, and back to the registrar. If they reject it, they just notify the registrar.
What happens if they reject it or just don't respond?
If the adjudicator rejects the referral or fails to accept it within that 4-day window, the registrar then must refer the application to another eligible adjudicator, again within 4 business days. And importantly for the claimant, there's no additional fee for this re-referral. This process continues until an adjudicator formally accepts the referral, at which point they are officially appointed to decide the dispute.
And the impartiality safeguards. Conflicts of interest.
Yes, the Act is very clear on this. An adjudicator is explicitly prohibited from adjudicating an application if they are actually a party to the construction contract themselves, or more broadly, if they have a conflict of interest that could affect their impartiality. There was a relevant case on this, Bright Days Hurston Clitty Ltd v. ATG Project and Property Solutions Flaty Ltd. It examined whether an adjudicator's prior involvement in related proceedings between the parties constituted a reasonable apprehension of bias. The court, applying the fair-minded lay observer standard, found that despite the previous involvement, the adjudicator in that instance did not exhibit bias. They looked at the adjudicator's statutory role and how they adhered to the legislative framework. It demonstrates that the bar for proving bias against an adjudicator is actually quite high.
That's a good safeguard, ensuring impartiality, even if the standard for proving bias is high.
Okay, so once an adjudicator accepts the referral, the respondent then gets their chance to formally present their side of the story, right? What's involved in submitting the adjudication response, and what are the crucial limitations on what they can actually say in that response?
Yes, once the respondent is notified that an adjudicator has accepted the referral, they may submit a written adjudication response. But, and this is a critical prerequisite, they can only submit a response if they initially provided the claimant with a valid payment schedule back when the claim was first made, as required by the Act.
So that earlier step is vital. No payment schedule back then means no formal response in adjudication now. That's the rule. It reinforces the importance of that initial payment schedule. If they did provide one, the response itself must identify the adjudication application it relates to, and it can and should include supporting submissions arguing their case. Now, the most crucial limitation here, and this is really key for respondents to understand, is that they cannot introduce new reasons for withholding payment in their adjudication response that were not already mentioned in their original payment schedule.
So you can't bring up brand new arguments at this stage.
Exactly. It's designed to prevent a respondent from ambushing the claimant with entirely new justifications for non-payment during the adjudication itself. The dispute should be focused on the issues raised initially. If new reasons are included in the response, the adjudicator actually has the authority to require the respondent to resubmit their response without those new reasons. This effectively ensures the adjudication stays focused on the disputes as they were framed back in the payment schedule.
So it's really about making sure the dispute stays focused on what was already on the table when the payment schedule was issued, which I imagine helps keep the process quicker and avoids scope creep.
Precisely. It maintains the focus and efficiency of the process.
Are there also distinct timeframes for submitting this adjudication response, and do they differ depending on whether it's a standard claim or one of those complex claims over $750,000?
Absolutely. The timeframes are very precise, and they do differ based on the claim's complexity, giving respondents more time for the potentially larger or more intricate complex claims. For a standard payment claim, those under $750K, the respondent must submit their adjudication response to the adjudicator within the later who dates, either 10 business days after they receive a copy of the adjudication application and supporting documents from the claimant, or 7 business days after they receive the notice of the adjudicator's acceptance.
Okay, so they get a minimum period after seeing the application and after knowing who the adjudicator is.
Correct. For a complex payment claim, those over $750K, they are given a bit more time. The response must be provided within the later of 15 business days after receiving the claimant's documents, or 12 business days after receiving the adjudicator's acceptance notice.
So longer periods for complex claims. Is there any way for a respondent to get even more time, especially for those complex ones?
Yes, there is a provision for extensions specifically for complex claims. The respondent can request up to an additional 15 business days. To do this, they need to apply in writing to the adjudicator within specific early timeframes, basically within 5 business days of receiving the application or 2 business days of the acceptance notice, whichever is later, and they must provide reasons justifying why they need the extension. The adjudicator then decides whether to grant it.
And once the respondent submits their response to the adjudicator, do they need to let the claimant know?
Yes, absolutely. Once they submit their response to the adjudicator, they must provide a copy of that response, including all submissions, to the claimant within 2 business days. This ensures both parties are fully aware of all the arguments and evidence being put forward, reinforcing transparency throughout the process.
Section 3. The adjudicator's role and decision-making. We've covered the application and the response, the back and forth between the parties. Now let's shift focus squarely onto the person at the center of this dispute resolution process, the adjudicator themselves. How are they appointed and regulated in Queensland? It sounds like it's a particularly stringent system compared to other states.
You're right, it is quite rigorous. Queensland has a unique requirement that really sets it apart. Unlike New South Wales and other eastern states, the BIF Act mandates that all adjudicators must be formally registered with the Adjudication Registry to be eligible to practice as an adjudicator in Queensland.
Registered. So it's not just about being qualified. They need formal registration.
Correct. It adds an extra layer of regulation and oversight. The aim is to ensure a consistently high standard of professional conduct and expertise across the board. The adjudication registrar and their staff, who manage the registry, are appointed by and fall under the direction of the Queensland Building and Construction Commission, the QBCC. This structure centralizes authority and aims for greater impartiality and control over the system.
And you mentioned earlier that the registrar has quite an extensive role. Can you detail their specific responsibilities again? It sounds like they do a lot more than just process paperwork. They seem to be the real backbone of the adjudication system.
Their role is indeed extensive, much more than just administrative. The registrar oversees the entire management and administration of the registry. This includes, as we discussed, referring adjudication applications to eligible adjudicators. But it also involves maintaining a comprehensive public register of all registered adjudicators, ensuring that register is accessible for inspection. They issue certificates confirming details from the register if needed. They also maintain and publish records of adjudicators' decisions, which is crucial for transparency and helps people understand how the act is being interpreted.
So you can see past decisions.
Yes, they're published. The registrar also manages the collection of fees and statistical data related to the whole adjudication process. Beyond administration, the registrar is responsible for administering those mandatory professional development requirements for adjudicators, developing and enforcing a code of conduct for them, offering consumer advisory services, and reporting to the government on the overall administration and effectiveness of the registry. It's important to stress that the registrar possesses the necessary powers to execute these functions impartially and transparently. They are not subject to direct direction from the QBCC commissioner in their specific day-to-day adjudication duties, which helps ensure their independence in handling claims fairly.
It's a very centralized and regulated approach indeed. Historically, though, I believe this wasn't always the case in Queensland. What led to this shift where the registrars took on so many of these functions rather than other bodies?
That's right. Historically, organizations known as Authorized Nominating Authorities, or ANAs, were responsible for appointing adjudicators in Queensland, similar to how it still works in some other states. However, these ANAs were abolished in Queensland following those major legislative amendments back in 2014.
Why were they abolished?
The change came about primarily due to persistent claims of bias in adjudicator appointments under the old ANA system. There were concerns about transparency and potential conflicts of interest in how adjudicators were being selected and assigned to cases by these private bodies. So the reform aimed to establish much more structured, centralized mechanisms for adjudicator appointment and regulation, removing that perceived potential for bias. Since 2014, the adjudication registrar has taken over all these functions, processing adjudications, registering the adjudicators, and referring matters to them directly. It was a direct response to a need for increased trust and perceived impartiality in the process.
So a definite move to clean up the system and ensure greater public confidence. And what about the actual regulatory framework that governs the adjudicators themselves once they're registered? What are the key policies and codes they have to operate under?
The regulatory framework is quite robust now. Under the BIF Act, specific regulations can be established and have been that detail various aspects related to adjudication qualifications. This includes the name of the qualification, the bodies authorized to issue it, the specific competencies required, and the elements needed for successful completion. These regulations also dictate the grading system for adjudicators, which we can talk more about. In this regard, the Building Industry Fairness, Security of Payment Regulation 2018, known simply as the Regulation, was released. This regulation formally approved two key policies that govern adjudicators day to day: the Adjudicator Referral Policy, which guides how the registrar assigns cases, and the Continuing Professional Development for Adjudicators Policy, which sets out those ongoing training and development requirements we touched on. The regulation also approved a specific code of conduct for adjudicators. These policies and the code provide the detailed rulebook for how adjudicators must operate, ensuring they maintain a high standard of professionalism and ethical conduct in their work.
That sounds like a lot of oversight and clear expectations.
Right.
Let's walk through the requirements then. For someone wanting to become an adjudicator in Queensland, what does it take? And then what do they need to do to remain registered? It sounds like quite a rigorous process even to get your foot in the door.
It is indeed quite thorough. To be registered as an adjudicator in Queensland, candidates must meet specific requirements. Primarily, they need to hold an accreditation that the registrar deems equivalent to an adjudication qualification. The registrar actually selects a private organization, a training provider, to deliver the adjudication training and certify potential adjudicators under the BIF Act.
What does that training involve?
Well, it involves a pretty substantial commitment of time, typically around 35 to 45 hours. It includes passing 2 written examinations. And crucially, candidates must demonstrate their practical competency by writing a reasoned adjudication decision based on a mock adjudication scenario, following the requirements of the BIF Act. This rigorous training covers a really comprehensive range of topics, everything from the role of the adjudicator and the registry, the procedural steps under the Act, practical adjudication skills for both standard and complex claims, ethics, principles of natural justice, acting in good faith, effective decision-making and writing skills, and essential legal and technical concepts relevant to construction disputes.
Is there any way around that initial training if you're already very experienced?
Yes, there is. It's worth noting that experienced professionals, maybe senior lawyers, engineers, quantity surveyors who can demonstrate comparable qualifications and extensive relevant experience can actually apply for registration without having to undergo that initial formal training program. Their prior experience can be recognized by the registrar.
Okay, so once someone is registered, perhaps after doing the training or based on experience, what are the ongoing requirements? You mentioned continuing professional development or CPD. Do they just get their certificate and that's it for a few years?
No, certainly not. Continuing professional development, or CPD, is a mandatory requirement under the BIF Act for all registered adjudicators. They must fulfill these CPD requirements each year to keep their registration active. And importantly, the rules state that fulfilling CPD is also necessary to be considered for further appointments or referrals from the registrar.
So it affects their potential workload too.
That's the theory. Although there's a common opinion amongst some adjudicators themselves that while CPD is absolutely crucial for maintaining active registration, it doesn't necessarily serve as a direct vehicle for securing more appointments in practice, given the number of adjudicators versus cases. The QBCC has introduced a specific CPD policy that details all the requirements in terms of the types of education and training activities that count. Some industry professionals have expressed concern that these requirements, while well-intentioned, might not significantly improve adjudication outcomes in practice and perhaps may be considered a bit excessive compared to the actual workload many adjudicators receive annually.
How much CPD is required?
Specifically, adjudicators are required to gather 10 CPD points each year to maintain their registration. These points can be obtained through various approved activities listed in the QBCC's CPD policy or other comparable means approved by the registrar. It implies a considerable ongoing investment of time and potentially resources for adjudicators just to keep their registration current.
Beyond the specific training and ongoing development, are there other broader eligibility factors that the registrar considers when assessing someone for registration or deciding whether to keep them registered? What kind of character and background are they looking for?
Yes, definitely. There are broader eligibility criteria defined in Section 161 of the BIF Act that the registrar must consider. They need to ensure that an applicant meets these criteria to uphold the quality and integrity of the whole adjudication process. These factors include things like the applicant's formal education and demonstrated competencies, their past conduct and performance in previous professional roles, any relevant criminal convictions they might have.
Okay, so background checks, essentially.
Yes. And whether they've had past registrations or licenses suspended or canceled in any field, their personal insolvency status, like bankruptcy, and their disciplinary history with any relevant professional associations they belong to. Their overall experience and qualifications are also weighed, of course, along with any other factors the registrar considers pertinent to their ability to fulfill the demanding duties of an adjudicator fairly and competently. An adjudication qualification itself signifies that an individual has met a specific competency standard set by a prescribed body. And it's important that applicants haven't committed what the Act calls relevant offenses, which includes serious indictable offenses or violations of related building and construction laws. It's really about ensuring they have both the right skills and the necessary integrity for the role.
It's clear that Queensland has put a lot of thought and regulation into who can even become an adjudicator, ensuring a pretty high bar for entry and ongoing practice. How does the registrar then assign specific cases once an adjudicator is registered and deemed eligible? And you mentioned a grading system. How does that affect which cases they can actually take on?
Right. The registrar utilizes that formal adjudicator referral policy we mentioned to guide how cases are assigned. Their first step when an application comes in is an initial assessment. They look at it to determine whether a Grade 1 or a Grade 2 adjudicator is appropriate, based primarily on the claimed amount, remember that $150 K threshold we'll talk about, and the apparent complexity of the issues in dispute. This initial assessment helps them get a clear picture of the specific skills and level of expertise likely required for that particular claim.
What if multiple adjudicators seem suitable? How do they choose?
If multiple adjudicators are deemed suitable based on their grading and expertise, the registrar aims for a fair distribution of work. They do this by considering the last occasion each of those suitable adjudicators was referred an application. The idea is to spread the workload around equitably rather than having the same few adjudicators getting all the cases. For those complex claims that specifically require a Grade 2 adjudicator, they might also consider the last time that specific Grade 2 adjudicator decided a complex matter, again, to balance experience on complex files with fair workload distribution.
Okay, let's talk about those grades. What defines Grade 1 versus Grade 2? How does an adjudicator move up, and what are the limitations of each grade?
The grading system is quite clear under the regulation. All newly registered adjudicators automatically start as Grade 1 adjudicators when their registration first becomes effective. Grade 1 adjudicators are limited in the scope of work they can handle. They can only decide payment claims where the amount claimed is less than $150,000, including GST. This allows them to gain practical experience on, generally speaking, smaller and potentially less complex matters first.
And how do they get upgraded to Grade 2?
To be upgraded to Grade 2, which allows them to handle claims of any value, including those complex ones over $750,000, an adjudicator typically must have adjudicated no less than 10 adjudication applications as a Grade 1. And importantly, at least 5 of those 10 applications must have been for amounts over $25,000.
So demonstrating experience across a range of values.
Exactly. It ensures they have a solid track record of handling a decent volume and value of claims before they take on the potentially much larger and more complex Grade 2 matters. Alternatively, the registrar does have the power to assess if an adjudicator's experience, perhaps gained interstate or in a similar field, is comparable to these specific requirements, even if they haven't met the exact numbers within the Queensland system. This provides some flexibility for highly experienced professionals transferring in.
So once an adjudicator Grade 1 or Grade 2 is appointed to a specific case, how do they actually conduct the adjudication process itself? What are the decision-making rules they have to follow? Do they have a lot of leeway in how they run things, or are they quite restricted by the Act?
An adjudicator has a clear statutory duty under Section 84 to decide the adjudication application and any related requests like time extensions as quickly as possible. They must adhere strictly to the specified time requirements we discussed earlier. During the process, the adjudicator has significant authority to manage the proceedings. They must determine their own jurisdiction, basically, decide if they have the power under the Act to hear the claim. They can assess if the application is frivolous or vexatious, meaning it lacks merit or is intended to harass. They can request additional written submissions from either party if they feel they need more information, but crucially, they must always allow the other party a fair opportunity to comment on those new submissions to ensure procedural fairness.
Can they call meetings?
Yes, they can set deadlines for further submissions. They can call informal conferences with the parties, although legal representation is generally not permitted in these conferences unless the adjudicator specifically allows it. And they can even go out and physically inspect any relevant matters on site if they think it's necessary.
What if one party just doesn't cooperate? Does that stop the process?
No, and this is a crucial point. An adjudicator's authority to make a decision is not compromised or halted by either party's failure to, say, make a submission on time, meet a deadline set by the adjudicator, or even attend a conference if one is called. They have the power to proceed and make a decision based on the information they do have, even if one party is uncooperative. This ensures the process keeps moving forward and can't be easily derailed.
That's important to keep the process moving and prevent deliberate delays by one side. What about the specific timelines the adjudicator themselves must adhere to for making their actual decision? Are they under pressure to deliver quickly?
Yes, the decision timeframes are also strictly regulated and quite tight. For a standard payment claim under $750K, the adjudicator must make their decision within 10 business days after what's termed the response date. For a complex payment claim over $750K, they have a bit longer, 15 business days after the response date.
And just remind us, what exactly is the response date?
The response date is defined as the date the adjudicator actually receives the adjudication response from the respondent if one is submitted. If the respondent was prevented from giving a response because they didn't give an initial payment schedule, it's the last day they could have submitted it according to the rules. Otherwise, if they just failed to submit it on time, it's simply the last day the respondent had under the Act to submit their response. Importantly, an adjudicator cannot actually decide the application before the respondent's response period officially ends, unless they determine early on that they lack jurisdiction or that the application is frivolous or vexatious. They have to wait for that response window to close.
Can these decision deadlines be extended?
Yes, there are provisions for extensions. Both the claimant and respondent can agree in writing to give the adjudicator extra time, and this agreement can even go beyond the maximum statutory period if they both consent. For complex claims specifically, if no such agreement is reached between the parties, the adjudicator can still unilaterally extend the decision period by up to 5 business days beyond the initial 15-day deadline. They must promptly inform the registrar of any extension they grant.
It sounds like a very structured process with tight timing.
Yeah.
What about consistency? Are adjudicators required to maintain consistency in their valuations if a similar issue, like the value of a particular item of work, comes up in a later claim between the same parties? Or can they just decide anew each time?
Yes, the Act specifically addresses this to promote consistency. Section 87 states that when an adjudicator determines the value of specific construction work or related goods and services under a contract, if that same valuation comes up in a later adjudication application involving the same work or goods under the same contract, the subsequent adjudicator must assign the same value. The only exceptions are if either the claimant or the respondent can convincingly demonstrate to the later adjudicator that the value of that work or those goods has genuinely changed since the last time it was assessed. Or, of course, if a court decision has subsequently altered that value, in those cases, the adjudicator must update their valuation accordingly. But otherwise, the previous valuation stands. This ensures a degree of consistency and predictability within the system so you don't have wildly different outcomes on the exact same valuation issue popping up repeatedly.
Okay, makes sense. Now, the moment of truth. The adjudicator's decision itself. What exactly does an adjudicator determine in their final decision, and what are the key requirements for that decision to be valid and enforceable?
At the end of the process, the adjudicator is responsible for determining several key things. Primarily, the specific amount of the progress payment, if any, that is owed by the respondent to the claimant. They also determine the precise date on which that amount became or becomes payable. And they determine the rate of interest that might be payable on that amount. Their decision-making process is strictly guided by the Act. They can only consider certain things: the relevant provisions outlined in the BIF Act itself, the terms of the actual construction contract between the partners, the payment claim and the payment schedule, if one was provided, and all the submissions, including supporting documents, that were properly made by both parties during the adjudication process.
So they can't just bring in outside factors or decide based on general fairness.
No. They are explicitly required to disregard any adjudication responses that were submitted late or were prohibited, like those containing new reasons not in the payment schedule. They may also ignore submissions that violate specific regulations. It's very much based on the Act, the contract, and the parties' formal submissions. The decision itself, including the reasons for reaching that decision, must be provided in writing unless both parties specifically agree beforehand that they don't require written reasons, which would be unusual. Finally, the adjudicator must provide the registrar with a copy of their written decision and details of their incurred fees and expenses at the same time as they provide the decision to the involved parties.
You mentioned the decision must include reasons. What about the quality of those reasons? Are they expected to be incredibly detailed legal arguments, or is there a different standard the courts look for? For you as a claimant or respondent reading that decision, how much explanation can you reasonably expect?
That's a good question. The extent of reasons required has been discussed in court cases, like Sierra Property Killed, Kia Ltd v. National Construction Management, PIA Ltd. The court noted that while there's no necessary list of matters that must be considered or addressed in every single decision, the requirement to provide reasons is informed by the very wide variation in the types and complexity of payment claim disputes that come before adjudicators. So there isn't a rigid checklist they have to tick off, but the reasons provided must be sufficient to actually explain how the adjudicator arrived at their conclusion. They need to allow the parties to understand the essential grounds for the decision based on the submissions made and the application of the Act. You should be able to follow the adjudicator's basic line of logic, even if it's not, a full-blown legal treatise like a court judgment might be.
Understandable, but not necessarily exhaustive. What if the adjudicator makes a simple mistake in their written decision, like a typo in a name or an obvious miscalculation in the amount? Could that be fixed easily, or is the decision absolutely set in stone once issued?
Yes. Fortunately, minor errors like that can be rectified relatively easily. The Act includes a slip rule in Section 89. If the adjudicator's decision contains a clerical mistake, an accidental error or omission, a significant miscalculation of figures, or a defect in its form, the adjudicator can correct it. This correction can be done on the adjudicator's own initiative if they spot it, or it can be done at the request of either the claimant or the respondent, or even at the request of the registrar. This ensures that minor administrative slip-ups don't unfairly invalidate an otherwise sound and properly made decision.
That's practical. Now let's talk about the financial aspects, the costs. How are the adjudicator's fees determined? And who is responsible for paying them? Is it always just the losing party who picks up the tab?
An adjudicator is entitled to payment for the work they do in adjudicating the application. This payment is based either on an amount or rate agreed upon beforehand between the adjudicator and the parties, or, if no amount was agreed, then a reasonable amount for the work done. This is subject to any maximum fees that might be prescribed by regulations. As for who pays, the default position under Section 95 is that both the claimant and the respondent are jointly and severally liable for paying the adjudicator's fees. This means the adjudicator could technically seek the full amount from either party if the other doesn't pay their share.
So initially, they're both on the hook.
Yes. Typically, the expectation is that they will share the costs equally, unless the adjudicator, in their decision, specifically decides otherwise based on certain factors. However, there's a catch. If an adjudicator fails to make a decision within the required statutory timeframe, including any valid extensions, they are generally not entitled to be paid any fees for their work on that adjudication unless they can demonstrate to a court that they were acting in good faith despite the delay. And the term adjudicating in this context covers the whole process, accepting the referral, considering the application and submissions, and making the final decision.
So how does an adjudicator decide on that proportional split of fees and expenses if they choose to depart from the default 50-50 split? What factors do they consider to determine who should pay what proportion?
When making their final decision on the payment claim, the adjudicator also has the power under Section 96 to determine the proportion of their own fees and expenses that should be paid by each party. They can also decide what portion of the claimant's adjudication application fee the respondent might have to reimburse to the claimant. In deciding this apportionment of costs, the adjudicator considers several factors related to the behavior of both parties throughout the process. This might include the relative success of each party in the adjudication, who won't on the main issues, whether either party participated for any improper purposes, the reasons why the respondent didn't make the progress payment in the first place, and the overall conduct of both parties during the adjudication process itself.
Conduct like?
Well, the adjudicator can look at the time they had to spend dealing with various aspects of the claim, perhaps caused by one party's unreasonable behavior, and any other factors they deem relevant. Conduct, in this context, specifically includes things like unreasonable actions, or attempts by the respondent to introduce those new reasons during the process that weren't in the original payment schedule. It's really a holistic assessment of who caused the dispute and how each party conducted themselves during the resolution process.
So it encourages parties to act reasonably throughout. Was it a particularly significant court case that clarified how these fees are handled if an adjudication decision itself goes wrong, maybe gets overturned by a court, or is found to be invalid for some reason?
Yes. The Sierra Property QLD Pataytayel Ltd v. National Construction Management PIDO Ltd No. 2 case provided some important clarification on fees in problematic scenarios. The court ruled that when an adjudicator's decision is nullified or set aside by a court due to a jurisdictional error, meaning the adjudicator stepped outside their legal authority, it doesn't automatically mean that one party, say the party who lost the court challenge, should be responsible for paying all of the adjudicator's fees for the flawed adjudication.
So the costs don't just automatically follow the court outcome.
Not necessarily for the adjudicator's original fees, no. The court indicated the initial joint liability might still apply or need separate consideration. It's an important distinction. The costs aren't simply shifted entirely just because a jurisdictional error occurred. Furthermore, it has been judicially decided in other cases that an adjudicator may not be entitled to be paid their fees and expenses if their adjudication decision was made late, outside the strict statutory timelines. This really underscores the critical importance for adjudicators themselves to adhere to those deadlines. If the adjudicator is late, their right to be paid for their work might be forfeited entirely.
Section 4. Enforcement and judicial scrutiny. So the decision is finally made, hopefully on time, the fees are sorted out. Now, the crucial part. How does a claimant actually get their money if the adjudicated amount isn't paid willingly by the respondent? What are the enforcement mechanisms available to you under the BIF Act?
Right, this is where the Act needs teeth. Once an adjudicator rules that an amount is owed, the respondent has a clear legal obligation under Section 90 to pay that adjudicated amount to the claimant. The deadline is within 5 business days of them receiving the adjudicator's decision, or by a later date if the adjudicator specifically determined a later date in their decision. The respondent also has an obligation to inform the registrar once the payment is actually made, and they need to do that within 5 business days of making the payment.
But what if they don't pay within that time? What's the next step for the claimant?
If payment isn't received by the deadline, the registrar plays a crucial role in the enforcement process. The registrar is required to issue an adjudication certificate to the claimant. This should happen within 5 business days of the registrar receiving the adjudicator's decision.
What exactly is in this adjudication certificate? And are there any situations where the registrar won't issue it, potentially leaving a claimant without that key enforcement tool?
The certificate is essentially the formal document you need for enforcement through the courts. It includes key details like the names and addresses of the claimant and respondent, the specific adjudicated amount that remains unpaid, the payment deadline determined by the adjudicator, details of any applicable interest rate, the adjudicator's fees payable, and importantly, a clear statement indicating that the certificate is made under the BIF Act. This is your official document to prove the debt determined by the adjudicator.
But can the registrar refuse to issue one?
Yes, there are specific, limited circumstances where the registrar is not obligated to issue the certificate. These include situations where the adjudicator's decision actually found that the respondent was not required to pay any amount to the claimant, or if it was determined that the adjudicator lacked jurisdiction in the first place to make the decision, or if the original adjudication application was dismissed by the adjudicator as being frivolous or vexatious. In those specific cases, the certificate won't be issued because there's no valid adjudicated amount to enforce.
Okay, that makes sense. This raises an important question, though. What if the respondent still doesn't pay, even after an adjudication decision has been made and the certificate has been issued? Are there other immediate avenues for the claimant, like that suspension of work you mentioned earlier, or do you have to go straight to court at that point?
Yes. Absolutely. That right to suspend work we touched on earlier becomes very relevant here. If the respondent fails to pay the adjudicated amount by the due date specified in the decision or certificate, the claimant has a powerful statutory right under Sections 92 and 98 to suspend carrying out construction work or suspend the supply of related goods and services under the contract.
How does that work in practice?
To exercise this right, the claimant must first give the respondent a written notice. This notice must clearly state their intention to suspend work and, crucially, must state that the notice is being made under the BIF Act. The suspension can then legally begin as early as 2 business days after this written notice is given to the respondent.
How long can the suspension last?
The suspension can last until the claimant has been paid the outstanding adjudicated amount in full. The Act actually says it lasts until 3 business days after the payment is received, giving the claimant time to remobilize. And there are crucial protections for the claimant during this suspension. If the suspension leads to the respondent trying to take part of the claimant's work away from them under the contract, the respondent must compensate the claimant for any resulting loss or expense suffered because of that removal of work. Moreover, the claimant is explicitly not liable under the Act for any loss or damage suffered by the respondent as a direct result of the claimant lawfully suspending work under this provision. This gives claimants significant leverage and can bring projects to a grinding halt until payment is finally made.
That's a very direct form of leverage indeed, which sounds highly effective in practice.
Right.
But if suspending work doesn't do the trick, or isn't practical, how is the adjudication certificate itself enforced legally? Does it mean going through a whole new court case from scratch?
No, thankfully it doesn't require starting a whole new case. The adjudication certificate has real legal weight. Under Section 93, It can be filed by the claimant directly in a court of competent jurisdiction, like the magistrate's, district, or Supreme Court, depending on the amount, as if it were a judgment for a debt owed.
So it essentially becomes a court order.
Pretty much, yes. It's filed along with an affidavit from the claimant confirming that the adjudicated amount has not been paid. Once filed correctly, it's enforceable in the same way as any other court judgment for debt. If a partial payment has already been made, the judgment will naturally only apply to the unpaid portion. Now, there's a crucial limitation in these specific enforcement proceedings in court. The respondent is explicitly barred by the Act from bringing any counterclaim against the claimant within those proceedings, or from raising any defense related to matters arising under the construction contract itself. They can't re-argue the merits of the original dispute.
So they can't try to offset the debt or argue about the contract work.
Not in the enforcement proceedings for the certificate, no. If the respondent wants to challenge the judgment based on the certificate, perhaps arguing the adjudication itself was invalid due to jurisdictional error, which we'll discuss, they generally must pay the full unpaid adjudicated amount into the court as security before they can even proceed with that challenge. This mechanism ensures the adjudicated amount gets secured quickly, fulfilling the Act's purpose of getting cash flowing, even if further legal arguments about the underlying contract or the adjudication's validity might ensue in separate proceedings later on.
That's a powerful tool to ensure the adjudicator's decision is honored quickly. I also understand there's a relatively new and potentially even more powerful mechanism involving a charge over the property itself. Can you explain that and how it could benefit a contractor who's still struggling to get paid after adjudication?
Yes, this is a significant addition to the enforcement arsenal introduced fairly recently under Section 100A. It's available specifically to head contractors in certain situations where they haven't received full payment for an adjudicated amount owed to them by the principal or property owner by the due date. It allows the head contractor to apply to register a charge over the specific property where the construction work was performed.
What does registering a charge actually mean for the contractor?
It effectively puts a legal encumbrance, like a lien, on the property title. This charge grants the head contractor a formidable right: the ability to ultimately seek permission from a court to sell the property if the adjudicated debt remains unpaid. It's a very strong measure.
Wow. Sell the property. What criteria need to be met to use this?
To pursue this charge over property, the head contractor must meet certain criteria. First, they must be owed an adjudicated amount that hasn't been fully paid by the due date. Second, they need to verify that the debtor, the principal, or a related entity of the debtor actually owns the property in question where the work was done. And third, critically, they must have already taken the step of lodging the adjudication certificate as a judgment debt in the relevant court, as we just discussed. It's a mechanism designed primarily to protect successful head contractor claimants from the risk of non-payment, particularly in situations where the principal's solvency might be a concern. It gives them security directly against the asset they helped improve.
That certainly sounds like a very strong final option. What happens if, going back a step, the adjudicator completely fails to make a decision within the required time? We know they might not get paid, but what recourse does the claimant have? Does the whole process just collapse or have to start over from scratch?
No, the claimant isn't left completely high and dry if the adjudicator fails to deliver a decision on time. The Act anticipates this possibility in Section 94. If an adjudicator fails to decide the original application within the required timeframe, including any valid extensions, the claimant has 5 business days from when the decision should have been made to choose one of 2 paths. Path 1. They can request the registrar to refer the original application to a different adjudicator. If they make this request, the registrar must refer it to another adjudicator within 4 business days, and importantly, there are no additional application fees for the claimant. Path 2. Alternatively, the claimant can choose to withdraw the first application and initiate a completely new adjudication application from the beginning, lodging it afresh.
What happens if they choose the first path, referral to a new adjudicator? Do they get to make new arguments?
If the claimant opts for the referral to a new adjudicator, that new adjudicator will generally only consider the submissions and documents from the original application, working within specified timelines related to the new referral. They don't usually get to add substantial new material. This mechanism is designed to ensure that the process doesn't completely stall or fail just because one adjudicator fails to meet their deadline, preserving the Act's fundamental intent for quick resolution one way or another.
So these decisions, whether from the first or a subsequent adjudicator, are designed to be quick and provide an interim but enforceable outcome. But what about the role of the courts beyond just enforcing the certificate? Can these adjudication decisions actually be challenged on their merits? What's the ambit of judicial review? How much can a court actually interfere with what an adjudicator decides?
Ugh. This is a really complex and heavily debated area, and it highlights a fundamental tension within the security of payment legislation itself. The original intent was certainly for these decisions to be fast and largely final, at least on an interim basis. To achieve this objective of quick resolution, the Judicial Review Act 1991 here in Queensland was actually amended back in 2007. That amendment specifically aimed to exempt adjudication decisions made under the payment legislation from the standard processes of judicial review. The clear legislative intent was to make these decisions largely unchallengeable in court, to keep things moving fast and avoid getting bogged down in lengthy legal appeals.
But this didn't quite stick, did it? I seem to recall some significant legal challenges that really changed the landscape on this across Australia.
You're absolutely right, it didn't stick. Following that 2007 Queensland Amendment, our courts initially took differing approaches. Some early judgments suggested judicial review was indeed no longer available, except perhaps for very specific types of fundamental errors like fraud or lack of basic jurisdiction. However, the landmark 2010 High Court of Australia decision in Kirk v Industrial Court of New South Wales profoundly changed this entire landscape, not just in Queensland but across all states. The High Court ruled unequivocally that state legislation cannot constitutionally preclude or prevent judicial review by a state Supreme Court for what's termed jurisdictional error.
Jurisdictional error. We need to define that. But what did Kirk mean for that 2007 Queensland Amendment trying to block review?
It meant that, despite Queensland's specific 2007 legislative attempt to oust judicial review, adjudication decisions made under the BIF Act and its predecessors in Queensland can always be judicially reviewed by the Supreme Court for jurisdictional errors. Consequently, that 2007 Queensland Amendment is now largely considered legally ineffective or a nullity in practice. It effectively reinstated the position that existed before the amendment. Adjudication decisions remain subject to review for jurisdictional errors. This, as you can imagine, creates an inherent tension. On one hand, you have the fundamental principle of the rule of law, which requires courts to have oversight to correct serious legal errors by decision makers. On the other hand, you have the core values of informality and timeliness that are absolutely central to how security of payment legislation is supposed to work. The courts are constantly trying to balance these competing interests.
Okay, so the door to court review is open, but only for jurisdictional error. What exactly counts as a jurisdictional error that would allow a court to intervene and potentially overturn an adjudicator's decision? It sounds like it's not just any mistake the adjudicator might make, but something much more fundamental relating to their power or process.
Precisely. It's a crucial distinction. Post-Kirk, and as further clarified in significant Queensland cases like North Build Construction PL v Central Interior Linings PL, an adjudication decision can be challenged and potentially set aside by a court on the grounds of jurisdictional error. Jurisdictional error essentially means the adjudicator has somehow stepped outside the boundaries of the power or authority granted to them by the BIF Act. Or, alternatively, it could be challenged for an error of law that is apparent on the face of the record, meaning the error is obvious just from reading the decision itself without needing external evidence. However, it's really important to emphasize that courts remain quite reluctant to interfere with adjudicators' decisions. They generally uphold the legislative intent for speed and finality on an interim basis. They will usually only set aside a decision if the error identified is clearly jurisdictional in nature or if there has been a significant denial of natural justice or procedural fairness to one of the parties. It's definitely not about the court simply disagreeing with the adjudicator's conclusion or correcting every minor mistake of fact or law.
Can you give some examples of what might constitute a jurisdictional error?
At its simplest, a jurisdictional error occurs when the adjudicator makes a decision that is outside the scope of their legal power. They might have, for example, failed to consider something the Act required them to consider, like a properly made submission, or they might have considered something the Act prohibited them from considering, like a late response with new reasons, or they might have fundamentally misunderstood the nature of their function under the Act, or perhaps they proceeded without a necessary precondition being met, like the existence of a valid construction contract under the Act. It's not just about the adjudicator making a mistake within their jurisdiction, like misinterpreting a contract clause, which is generally not jurisdictional error. It's about them making a mistake about the limits of their jurisdiction or power itself. The courts also sometimes distinguish between an objective jurisdictional fact, something external that must exist for the adjudicator to have power, like valid payment claim existing, and a subjective jurisdictional fact, which relates more to the adjudicator's state of mind or evaluation, like their determination that an application is frivolous. While both are threshold issues, only allegations concerning objective jurisdictional facts usually require full, independent consideration by the reviewing court. Subjective ones are often assessed more based on whether the adjudicator's process aligned with legislative intentions.
That distinction is interesting. Have there been any recent changes that affect how courts handle these jurisdictional error challenges?
Yes, actually. Recent amendments to the BIF Act introduced a provision, Section 104, that allows the courts, when they find a jurisdictional error, to potentially sever the parts of the adjudicator's decision that are affected by the error from the parts that are unaffected. This means if only a portion of the decision is flawed due to a jurisdictional error, the court might be able to cut out just the problematic part and leave the rest of the decision standing and enforceable.
So it's not necessarily all or nothing anymore.
Exactly. This change may have actually reduced the number of court applications challenging decisions because respondents can no longer strategically challenge an entire large decision hoping to invalidate it all if only a relatively minor part is actually affected by a jurisdictional error. So to summarize this complex area, the only way to get a court to review and potentially overturn an adjudication decision made under the BI Act is on the grounds of jurisdictional error, or that related concept of error of law on the face of the record, or denial of natural justice, which often overlaps with jurisdictional error. Common examples of things that have been found to be jurisdictional errors include an adjudicator failing to perform a required action mandated by the Act, like failing to consider a key document or failing to allow a party a fair chance to present their position, an adjudicator overstepping their authority, like considering a prohibited document or deciding something completely outside the scope of the payment claim, or an adjudicator proceeding without essential objective jurisdictional facts being established, like the existence of a construction contract or a valid payment claim.
That's a very clear summary of where the courts draw the line, trying to protect the integrity and speed of the process while still allowing oversight for fundamental errors. Can you synthesize some of the other crucial legal principles that have emerged specifically from Queensland courts regarding the BIF Act's day-to-day operation? What are some of the key practical takeaways for people in the industry from all these years of legal interpretations and court cases?
Absolutely. Over the years, the Queensland courts have established quite a body of principles that guide how the BIF Act operates, and these are vital for anyone engaging with the system to understand. Here's some key takeaways. Firstly, any adjudication decisions that do not comply with the essential statutory requirements of the Act are considered void, and a court may then make declarations about the legal position or grant injunctions, orders to do or not do something accordingly. Compliance is key. It's absolutely fundamental that adjudicators must correctly identify the existence of a construction contract as defined by the BIF Act. If the agreement between the parties doesn't legally qualify as a construction contract under the Act, the adjudicator has no jurisdiction, and the whole process might fail. A jurisdictional error will arise if an adjudicator departs from the only matters they are allowed by the Act to consider in making their decision. Remember that list: the Act's provisions, the contract terms, the payment claim and response, and all properly made submissions. If an adjudicator, for example, bases their decision on what they personally regard as a fair thing to do outside of these specific parameters, that's likely a jurisdictional error.
But simple mistakes aren't enough.
Correct. Importantly, where matters are entrusted to an adjudicator for decision under the Act, a decision involving a mere error of law, like misinterpreting a legal precedent, is not, for that reason alone, considered a decision beyond their jurisdiction. Similarly, an adjudicator who misconstrues a relevant provision in the construction contract, leading perhaps to an incorrect calculation of the amount owed, does not, by that error alone, make a jurisdictional error. It's a mistake within their jurisdiction, not outside it. However, critically, an adjudicator's complete failure to include reasons for their decision will generally amount to jurisdictional error because the Act requires reasons. Yet, the mere absence of certain detailed provisions in a contract or an adjudicator's failure to give absolutely exhaustive, minutely detailed reasons for every single point will not usually constitute jurisdictional error. There's a balance.
What about licensing?
A very important point. If a contractor carries out building work for which they do not hold the required QBCC license, they will generally have no recourse under the BIF Act to recover payment for that unlicensed work. Being properly licensed is fundamental.
And lodging multiple claims.
If a claimant tries to lodge two separate adjudication applications relating to the exact same payment claim, the second application will be invalid. However, the first validly lodged application will remain unaffected. You can't have two bites at the same cherry simultaneously.
What about the form of claims and schedules?
Courts have shown some flexibility. An email containing attached invoices that clearly refer to the same date and the work performed under one contract has been deemed capable of being a valid payment claim. They look at the substance. However, while courts try to avoid overly technical or narrow interpretations of payment schedules, the document submitted must still meet the minimum statutory requirements of the Act. It has to clearly identify the payment claim it's responding to and must specify the amount, if any, the respondent proposes to pay.
What about termination?
If a construction contract is terminated, the final reference date for making a payment claim under the Act is the date of termination itself, unless the contract says otherwise. This provides a clear endpoint for claims after termination.
Can you claim retention money?
Yes, a payment claim is generally valid even if the amount claimed includes retention monies held under the contract.
Timing of the decision.
This is critical. An adjudicator's failure to make their adjudication decision by the strict statutory deadline renders any late decision void and unenforceable. Timing is absolutely everything for adjudicators.
What about the basis for valuation?
An adjudicator will likely exceed their jurisdiction if they decide to apply a rate or method for valuing work that was not proposed or argued by either party without providing a sufficient explanation for doing so and, crucially, without giving the parties an opportunity to comment on that new approach. That can be a denial of natural justice.
Service of documents.
When serving an adjudication application, it's crucial to properly serve all necessary attachments. Simply providing a hyperlink to documents stored in the cloud, like Dropbox or OneDrive, has been found to be insufficient for proper service under the Act. You need to ensure direct delivery of the actual documents.
Detail in the claim.
A payment claim that lacks sufficient detail to allow the respondent and the adjudicator to identify the specific construction work or related goods and services to which the claim relates is likely to be invalid. It needs to be clear what you're claiming for.
Raising objections.
If a respondent believes there's a jurisdictional issue, like this isn't a construction contract, they should raise that objection in their payment schedule so it can be considered by the adjudicator or courts from the outset. Delaying can be problematic.
And finally, issue estoppel. What's that?
Issue estoppel applies in adjudication. This legal principle essentially prevents issues or arguments that have already been formally determined in an earlier adjudication between the same parties under the same contract from being re-argued in a subsequent adjudication. Think of it as the legal system's way of saying, you've already had your shot at arguing this specific point and it's been decided, we're not revisiting it again in this forum. It aims to provide some finality to decided issues within the adjudication process. So if you lost on a particular argument about, say, a variation's value in one adjudication, you generally can't just try to relitigate that exact same point in a new payment claim adjudication later.
That's a very thorough rundown of the guiding legal principles shaped by the courts. It gives a much clearer picture of how the BIF Act operates in practice. Beyond these specific legal rules and errors, the broader concept of denial of natural justice, or procedural fairness, often comes up in legal challenges to adjudication decisions. How does that fundamental principle apply within the intentionally rough and ready nature of adjudication, where things are meant to be quick and not a full court hearing?
That's right. The courts definitely recognize the intentionally rough and ready nature of the fast-track adjudication process. It's designed for speed, not perfect legal precision. And this recognition does make challenging an adjudicator's decision on the grounds of procedural unfairness or denial of natural justice quite difficult in practice. There's been an ongoing debate in the courts over the years about the threshold. Does any denial of natural justice, however small, invalidate the decision? Or does the denial have to be substantial to trigger a court's intervention?
What have the courts said?
Well, different cases have perhaps emphasized slightly different aspects. For instance, in Vice Constructions Limited v. Cockburn, the court indicated that there can be no partial compliance with a statutory obligation to accord procedural fairness, which might suggest that even a minor breach could potentially be grounds for finding a jurisdictional error. However, in other significant cases like John Holland Fitty Limited v. Walsh Marine Services Politi Limited, the emphasis was more on the denial needing to be substantial to actually void the decision. And that judgment even suggested that relief might be denied by the court if it could be shown that, even if perfect fairness had been accorded, it would have ultimately made no difference to the outcome of the adjudication anyway.
So it's not always clear-cut. Can you give an example of something that would likely be considered a significant denial of natural justice?
Yes, a clear example would be if an adjudicator determines that an applicant is entitled to payment based on a particular legal argument or factual basis that neither party actually argued for or put forward during the adjudication. This was seen in the case of Oswald Bros Plate Ltd v. Jalon Pacific Plady Ltd. That's generally deemed unfair because the parties never had an opportunity to address or rebut that specific line of reasoning the adjudicator came up with themselves. However, on the other side of the coin, a case like ABC Glass and Aluminium Plady Ltd v. Nick Nominees Plady Ltd and Anor clarified things a bit. It suggested an adjudicator doesn't necessarily breach natural justice just by referencing a case authority or legal principle that neither party cited, or by failing to specifically invite further submissions on it if that reference doesn't actually influence the core evidence-based findings that resolve the issue in dispute. So it really comes down to whether the fairness of the process, in substance, was materially impacted by the adjudicator's action or inaction, not just whether there were minor procedural imperfections along the way.
And briefly, how do other concepts like acting in good faith fit into this judicial review picture? And what's the typical approach of the courts when it comes to sending back or remitting invalid decisions to the original adjudicator for reconsideration?
The issue of good faith has also generated considerable judicial debate, particularly regarding whether the Act implies a broad duty for adjudicators to act in good faith, or just a narrower one related to specific powers. While a lack of good faith in exercising administrative power is generally considered capable of being a jurisdictional error, simply arguing that an adjudicator didn't act in good faith isn't usually enough on its own to invalidate a decision if the core statutory requirements have otherwise been met. It remains a somewhat nuanced area as explored in cases like McNabb Developments, QLBBIS, Plady Limited v. MAK Construction Services, Plady Limited. Regarding remittal sending a flawed decision back to the original adjudicator, the courts in Queensland have generally shown a strong reluctance to do this when they find an adjudication decision is invalid due to jurisdictional error.
Why are they reluctant to send it back?
Their reasoning is primarily based on prioritizing the quick, cheap, and simple processes envisaged by the Act. They feel that sending it back to the same adjudicator might just prolong the dispute, potentially undermine the speed and finality principles of the Act, or might not be appropriate if the error was significant. So if a court finds a decision is invalid, they are more likely to look to other remedies, like simply making a declaration that the decision is void and unenforceable, rather than remitting it back to the same adjudicator for a do-over. This reinforces the idea that these adjudication decisions, while technically interim, are generally meant to be final in their specific form unless overturned completely by a court.
Section 5. The system and practice effectiveness and challenges. Okay, that's been a truly comprehensive look at the legal framework, the processes, the enforcement, and the judicial scrutiny surrounding Queensland's security of payment laws. Let's zoom out now for the final section and look at how this whole system is actually performing on the ground. Does the BIF Act, with all its complexities and evolution, really work as intended? What do the statistics tell us about its effectiveness in resolving disputes quickly?
That's a crucial question, isn't it? How is it actually functioning day to day? The Queensland Building and Construction Commission's annual report gives us the best available snapshot, although we need to remember the latest publicly available detailed report is usually for the preceding financial year. So, currently, the 2022-2023 financial year. According to that report, a total of 262 adjudication applications were lodged with the registry in that financial year.
262 across the whole state.
Yes, across all of Queensland. Of these, 225 were classified by the registry as standard claims under $750, and the remaining 37 were complex claims over $750K. This does highlight that the dual scheme with its two tracks is actively being used, although standard claims clearly make up the vast majority.
And how many decisions were made?
In terms of outcomes, a total of 172 adjudication decisions were actually released by adjudicators during that same year. 152 of those related to standard claims and 20 related to complex claims.
What about the money involved in the speed?
Well, the average claimed amount across all those applications lodged was quite substantial, coming in at just over $1.1 million. The average adjudicated amount what the adjudicators actually awarded was $886,097. Crucially, in terms of speed, which is a key goal of the Act, the average time taken for a decision on a standard claim, measured from the date the application was lodged to the date the decision was released, was just 23 business days.
23 business days, that sounds pretty quick.
It is. It aligns well with the Act's aim for rapid resolution. For the complex claims, which have longer statutory timeframes, the average decision time was less than 57 business days. Still a relatively swift resolution, considering these are disputes over $750,000, often involving more intricate issues. So, on paper at least, the system appears to be operating and processing the claims that come through it quite efficiently.
That does sound fairly efficient for the cases that are actually going through the adjudication process. But with all these rigorous processes we've discussed and the strict registration and CPD requirements for adjudicators, what's the situation like regarding the supply and quality of these adjudicators? Are there enough of them? And is there a concern they might struggle to maintain their expertise in such a specialized and evolving field, especially if case numbers fluctuate?
That's where an interesting and potentially problematic dynamic emerges for the system. The same annual report indicated that, at that time, there were currently 149 registered adjudicators in Queensland.
149 adjudicators for only 262 applications.
Exactly. Now, on the face of it, 149 might sound like a healthy number, perhaps even suggesting an oversupply when you compare it to the 262 applications lodged annually across the entire state. If we connect this to the bigger picture, an oversupply might seem like a good thing initially, ensuring there's always someone available and preventing delays in appointments. But it actually poses a significant challenge to maintaining consistent expertise and deep engagement in this very specialized field.
How so?
Well, with such a large pool of registered adjudicators and a relatively low number of cases being lodged each year overall, it means many individual adjudicators may not be receiving a sufficient workload. They might only handle 1 or 2, or perhaps even 0 cases each year. The potential consequence of this is a real concern about a lack of practical exposure and motivation for some adjudicators to stay truly current with all the legislative developments and complex case law we've been discussing. There are definitely concerns within the industry that this low individual case volume might, over time, risk compromising the overall quality and consistency adjudication, simply because adjudicators might not be handling enough actual cases to continually hone and maintain their skills and their deep understanding of these constantly evolving laws. It's a bit of a catch-22 situation. You need enough adjudicators to ensure availability and avoid conflicts, but having too many might inadvertently dilute the overall pool's active, hands-on expertise.
That's a really valid concern, that potential trade-off between quantity and consistent quality could be a real underlying problem for the system's long-term health.
And speaking of the number of applications being lodged, I understand there's been a pretty significant decline in the total number of adjudication applications over the years, particularly since those major legislative overhauls you mentioned earlier, like the ones in 2014 and the introduction of the BI Act. What's the story there, and what might that trend tell us about the system's perceived effectiveness or perhaps its challenges?
Yes, this is a very notable trend that really stands out when you look at the historical data. There has been a quite significant decline in the annual number of adjudication applications being lodged in Queensland, particularly following that major legislative overhaul back in 2014, which, among other things, abolished the ANAs and introduced the registrar system. To put it in perspective, in the years leading up to those changes, say between 2012 and 2014, an average of around 707 adjudication applications were lodged annually in Queensland.
707 per year back then.
Around that, yes. Now, fast forward to the more recent period, looking at the average between 2021 and 2023, and that annual average has dropped sharply to just 278 applications per year.
Wow, that's a huge drop, less than half.
It is. It's a substantial reduction, more than a 60% decrease from the peak years. What's particularly interesting, and perhaps a bit concerning from a policy perspective, is that there has been relatively little in-depth research conducted or published over the years trying to pinpoint the precise causes of this significant decline. We also lack solid data on how these various legislative reforms, including the BIF Act itself, have actually impacted the overall use of the Act by the industry.
So this raises a really important question, doesn't it? Why the sharp drop in applications? Is it because the system, particularly post-BIF Act, is working so well, perhaps encouraging earlier payment and resolution, meaning fewer disputes actually escalate to formal adjudication? That would be the positive interpretation.
That's one possibility.
Or Is it the opposite? Are parties, particularly maybe smaller claimants, finding the process too complex, too costly perhaps despite the intention, or too legally uncertain given the potential for judicial review? And are they therefore choosing other avenues for dispute resolution? Maybe they're opting for mediation more, or negotiation, or perhaps even just writing off smaller debts rather than entering the formal adjudication process.
Those are exactly the questions that need asking.
And what might this ongoing trend of lower application numbers mean for the future confidence in the BI Act as the primary go-to mechanism for resolving security of payment disputes quickly and effectively in Queensland? That's definitely something significant to consider, and perhaps a bit of a puzzle that the industry and policymakers are still grappling with.
It certainly is. The reasons behind that decline are likely multifaceted and warrant closer examination to ensure the Act continues to meet the industry's needs effectively.
Well, that was a truly comprehensive deep dive into the BIF Act and Queensland's security of payment legislation. It's absolutely clear that understanding this framework isn't just a legal nicety for the lawyers. It's an absolute necessity for anyone working in the building and construction industry here, whether you're a principal, a head contractor, a subcontractor, or a supplier. Before you go, please don't forget to share, like, or subscribe. Also have a look at other episodes and visit CM Guide website for better insights on this topic.
Ultimately, the BIF Act, for all its inherent complexities and its ongoing cycle of refinements and amendments, really represents a critical framework. It's designed fundamentally to ensure fairness and, crucially, to maintain that vital cash flow throughout the contractual chain in what is a really vital industry for the state's economy. Its journey, the evolution we've traced today, reflects that continuous effort by lawmakers in the industry to try and strike that difficult balance, the balance between speed and informality on one hand, and robust procedures and access to justice on the other for all parties involved. Staying abreast of these developments, understanding how the Act works and how it's changing, is not just good business practice anymore. It's pretty much essential for successful project delivery and financial survival in Queensland's construction sector today. What's fascinating, I think, is how these laws, while undeniably complex, fundamentally aim to keep the wheels of construction turning by ensuring payment flows. And that constant evolution itself is perhaps the strongest testament to their ongoing importance.